Every day in the USA, people find themselves in court.
We will go on the record in the matters 25 CF 112, 25 CF 131, 26 CF 18. State of Wisconsin versus Joshua Mersha. The state appears through Assistant District Attorney Jose Vila in person. Mr. Mersha appears in person in custody with counsel Emma Hanu. We're set today in this matter for a plea and sentencing. Ms. Hanu, is this matter proceeding as such?
Yes, Your Honor.
I do have in front of me in my electronic file a plea questionnaire waiver of rights form. It appears to be signed by Mr. Mersha. Is that correct, Mr. Mersha?
Indeed, it is.
All right, Ms. Hanu, can you please recite the agreement for the record?
Thank you, Your Honor. The agreement reached by both parties is that Mr. Mersha would plead to count 1 in 25 CF 112, operating while intoxicated, a fourth offense. The remaining counts in this case, as well as 25 CF 131, 26 CF 18, would be dismissed and read in. Mr. Mersha would be ordered to serve 165 days of conditional jail in line with IDIP guidelines, as well as 2 years of probation and applicable costs and fees.
He understands conditional jail means no good time.
Correct, Your Honor.
Okay, how many days of jail credit does he have to date?
He has 125 days of credit, Your Honor. We would be requesting to allow Mr. Mersha to serve the additional 40 on electronic home monitoring.
All right. And he completed the IDIP except for the victim impact?
He completed the victim impact, Your Honor. It is the 8 hours of jail credit. There may be a slight discrepancy in the email I received from the jail and the jail credit. Mr. Mersha believes he has 131 days. The email I received is 125. I can ask for a double clarification.
Well, I'm going to tell you, if it came from the jail, it's accurate, but they can double check, and especially if it came from lieutenant or captain, but you can always ask to have it re-looked at. Okay. And Mr. Mersha, that's the agreement that you've reached?
That's the agreement that we discussed, and other than the discrepancy of the 125 versus 131 days, I was in custody in Minnesota in transport.
Awaiting
3
extradition
days.
on the.
And
So-
in addition to that,
That could be something that maybe the jail captain or lieutenant wasn't aware of. They can look at that. But my question is that the agreement you reached?
yes,
Okay, so you're pleading guilty to 1 count of OWI fourth with IDIP guidelines, with conditional jail and probation. And then the other counts in the other 2 cases would be dismissed and read in for purposes of sentencing. Mr. Vila, argument as to why this is in the public interest?
Thank you, Your Honor. I think necessarily we want to incentivize folks to complete the IDIP program as best as they are able to while they're in custody here at the Burnett County Jail or wherever they may be. I think if we did not extend that, we would necessarily disincentivize folks from taking advantage of the
Slow
program.
down.
I'm sorry. We would necessarily.
And then I'm gonna deviate your argument to the fact of, yes, he was completing the IDIP program, but yes, he was completing the program and only had the 1 leftover part and component to complete when he got the alleged 2 felony bail jumps of 2 drinking after going through the IDIP. So public interest argument.
Public interest argument is that he's going to be placed on supervision for a period of 2 years, and he's going to have his driving privileges permanently revoked. So if he reengages in these behaviors or reengages in alcohol abuse to the point that necessarily impacts the community in a negative way, he could face revocation and go straight back to prison.
Okay, all right. And you're not certain on the jail credit. You're going to leave that to captain or lieutenant?
Yes, Your Honor, that's correct.
All right. So I have in front of me a plea questionnaire waiver of rights form, Mr. Mersha. Ms. Hanu, do you have an electronic copy that you're looking at right now?
I will pull it up right now, Your Honor.
Mr. Mercia, is that the document that your attorney went over with you?
It's loading, Your Honor.
Yes, that appears to be my signature, and I do recall signing this document.
All right. Did your attorney thoroughly go over that document with you, essentially word for word?
In detail, yes,
And you understood everything completely?
I did.
If you didn't by chance understand something, did you ask her to explain it until you did so? Until you fully understood everything?
I understood initially when there was no question.
All right.
It was clear, yes.
So you're pleading guilty to one count of OWI 4. You're 43 years old. You have 12 plus years of schooling. You can read, write. You understand the English language. Is that all correct?
Yes,
Your attorney went over with you what the state would have to prove your guilt beyond a reasonable doubt?
yes, she did.
And did she go over the minimums as well as the maximum possible penalties you face?
Yes, Your Honor.
You are not receiving treatment for mental illness or disorder, and you've not had any drugs, alcohol, or other medications within the last 24 hours.
No, I have not.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on that first page of the document. Next to the rights, there are boxes. Each of those boxes is checked. That tells me that your attorney thoroughly went over those rights with you. Did she do that?
Yes, she did.
And do you understand them completely?
Yes,
Do you understand that by pleading guilty, you're waiving and giving up those rights?
I do.
Do you understand, or excuse me, do you need me to go over those rights with you in any more detail?
No, that's not necessary. Thank you.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation? I have to ask that to everybody, but do you understand that?
Yes, I understand that.
Okay. Do you understand you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
Yes,
You'll no longer be able to vote in any election until your civil rights are restored.
yes,
Do you understand the state would have to prove as to operating a motor vehicle while under the influence of fourth offense that on or around Friday, July 25th, 2025, in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant. Do you understand what the state would have to prove?
I do.
Do you understand that they would, that this would be counted as your fourth offense?
Yes,
Do you understand that upon conviction, you shall be fined not less than $600 and imprisoned for not less than 60 days due to your number of convictions, but you could be fined up to the maximum of $10,000 or imprisoned up to the maximum of 6 years of incarceration or both? Do you understand the minimum as well as the maximum possible penalties?
yes,
Do you understand that there is an agreement here that's been reached as it relates to following the IDIP guidelines and for the court to order 165 days of conditional jail and 2 years of probation? Do you understand I'm not bound to follow any agreement that's been reached by the parties?
I do, Your Honor.
I could sentence you all the way up to that maximum possible penalty, or I can do a minimum penalty or anywhere in between if I think it is warranted. Do you understand that?
I do.
You still wish to proceed and enter a guilty plea?
I do.
Did you go over the criminal complaint with your attorney? And in particular, there's that section, it's called the probable cause section, where it basically says what happened that day and why you were charged with an OWI 4th.
Thoroughly in detail.
And so you understand those facts as they are laid out?
I do.
For the most part, are those facts accurate?
Yes,
Are you pleading guilty to an OWI 4th conviction because you are guilty?
yes,
Ms. Hanu, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty today?
not directly or implied.
So you're doing so freely and intelligently, telling the court you fully understand what you're doing
Indeed,
and voluntarily?
absolutely.
Has your attorney represented you competently?
Yes,
Has she answered all of your questions?
promptly and concise.
And she's looked at this matter thoroughly?
I believe and feel so.
And she's looked at the evidence and the discovery, and she's discussed that with you?
Yes,
Has she discussed with you a potential for any legal defenses or a lack of defenses in this case?
several conversations of strategy to approach this case have been
And she
made.
discussed with you what it would mean if you wish to go to a jury trial?
Absolutely.
And it's your decision and desire to plead guilty today.
Yes, it is.
Are you satisfied with her services?
Absolutely.
Do you have any questions for the court or for your attorney before I proceed?
No, Your Honor.
Ms. Hanu, do you believe that your client is entering a plea freely, intelligently, and voluntarily, and fully understands the rights he's giving up here today?
Yes, Your Honor.
Mr. Mersha, as to count 1 OWI 4th and H felony, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1 in 25 CF 112. Count 2 will be dismissed and merged in with count 1. The other 2 cases will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Vila.
Thank you, Your Honor. I do believe the joint recommendation here is appropriate. Again, while Mr. Mersha did complete the IDIP program to the extent that he could while in custody, more importantly, I don't think he has a felony conviction outside of today. That changes here today. He's walking away with a felony conviction on his record. And furthermore, if he reengages in such problematic behaviors, he's going to face harsher punishments as it relates to operating while intoxicated. He's going to have his driving privileges permanently revoked from this, hence protecting the need to protect the public. And I think the supervision piece here is also clearly needs to be in place. This is someone who has an alcohol abuse problem, who apparently just seems to not be able to keep on the straight and narrow without having some kind of supervision there. That's why I think this piece, again, the need to protect the public and that hammer or the carrot, so to speak. Should he do what he needs to do, address his rehabilitative needs, this will be the end of it. Should he not, he faces potential revocation and goes back to prison. With that, I would ask the court to adopt. Thank you.
All right, thank you. Before I ask for argument, my question, I guess I'm confused with what you had said before. If he's done everything for the IDIP, did he do 250 hours of community service?
No, Your Honor, that was the component that was missing.
Okay, so that 250 hours, which could mean an additional 32 jail days if he wishes to convert it, or he can complete that. Okay, Ms. Hanu.
Thank you, Your Honor. I believe that this agreement is in line with a proper agreement. Mr. Mersha is an out-of-state resident. His support system is in Minnesota with his father, his family, and his friends. I don't think it's a secret to anybody that Mr. Mersha has a severe alcohol problem. Looking at the totality of circumstances in this case, as the court is probably aware, it's hard to kick addiction. It's hard to get sober. As the state pointed out, Mr. Mersha will walk away today with his first felony conviction. That is something that is not taken lightly. He loses a number of rights. He won't get his license back. He has served a pretty significant amount of jail time for somebody who hasn't really been to jail before. I think this might genuinely be Mr. Mersha's rock bottom. He is here today to take responsibility for his actions, all of them. I think this would be an appropriate agreement. The adding of probation rather than just the conditional jail gives, I think, the court the assurance that the public will be protected. Somebody will be there to monitor Mr. Mersha as he continues to probably stumble through sobriety. We would additionally be asking that a portion of Mr. Mersha's bail money be appropriated for him to do EHM for the specific reason that Mr. Mersha is an out-of-state resident. But him being able to go home and start working again and get on track to pay what I imagine are going to be pretty significant fines and fees stemming from this course of conduct would allow him to get back on track and reintegrate into the community in a successful and productive way. And I would ask Your Honor to follow the agreement.
All right, Mr. Mersha, is there anything that you would like to add or you would like the court to be aware of?
Oh, Your Honor.
All right. In sentencing an individual, the court looks at multiple things. First and foremost, the court looks at the nature and the gravity of the offense. How serious is this matter? Then the court looks at you, the defendant, and your past criminal record, any needs for any rehabilitation, your history, your education, employment, all of those things. Then the court looks at the need to protect the public. In sentencing, again, you were given a benefit of the deal to plead guilty to an OWI fourth and have the other two cases, which do stem from engaging in consumption of alcohol on a no drink and absolute sobriety, as well as while you were going through an IDIP program. Those were dismissed and read in for the court as it relates to sentencing, and the court can look at those for sentencing purposes. An OWI fourth is a very serious matter. It's telling the court not only have you engaged in and operating while under the influence of this offense this time, but 3 other times. It is serious. The legislators tell us it's serious because they have increased within the last few years an OWI 4 from a misdemeanor up to a felony level conviction. If I'm looking at this case and I'm looking at the blood alcohol content that I have in my electronic file, it indicates that it was a 0.367. That is a massive amount of alcohol in your system. And I believe in one of the other OWIs, well, they're not allegations, they're dismissed and read in counts. I believe that your blood alcohol content was again extremely high, but I can't recall which one it was high in, or maybe both. That's telling me that you have an alcohol issue, you're an alcoholic, plain and simple. You have issues with alcohol and you need to take those seriously. You were in the intoxicated driver intervention program, which is supposed to be an in-depth program to teach you and for you to learn how to notice your issues and your problems with alcohol and how to address those. And while in the course of doing the program, from this initial OWI conviction of July 25th, 2025, while you were in the midst of doing that program, there was the drinking to excess on August 23rd, 2025, and drinking to excess again on February 6th, 2026. And at that time, while you were in the program, that was telling the court that you weren't taking that program seriously, or you needed more in-depth services, which you can get on probation, perhaps some type of alcohol treatment, inpatient treatment, maybe some outpatient treatment, something that is going to address your underlying issues with alcohol. The court has to look at, you are a person who has the ability to rehabilitate or to take services and to learn from them. I have no doubt in my mind. You appear, I'm going to tell you, Mr. Mersha, in every hearing that we've had, even though you haven't said many words, the words that you have said and how you have said them tell me that you are an intelligent individual. You are smart, you understand not only the very basics, but you understand a lot more about this. I don't know what you do for a living. I don't know what you've done for a living. I don't know beyond your education of 12 plus years of schooling. But just from the words and the interaction you've had with the court, you're a smart man. You're a smart man. And I can tell that. I have to look at needing to protect the public, and we're looking at here the first OWI offense, and we're looking at the 2 bail jumps with the ingestion and the consumption of alcohol, and again to excess. And so I have to use that in my sentencing. So here I do believe that probation is appropriate for this OWI conviction. So I will place you on probation for the period of 2 years. I am going to order 165 days of conditional jail. while you are on probation, absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, regular alcohol and illegal substance testing, gainful employment or higher level education. I am ordering 258 hours of community service. That includes the 8 hours you have not yet been able to complete, as well as the 250 hours that go with the IDI guidelines. I am going to give you 6 months to be able to complete that 258 hours of community service. Generally, you're supposed to have it completed at the date of sentencing. However, you're going to be on probation, and so the court will give you 6 months to complete that. You can do it at any nonprofit, Salvation Army, a church, a food drive, a clothing drive, anything like that. It must be on letterhead of the nonprofit, signed by the person overseeing it, saying that Mr. Mersha has completed on February 1st, 2026, 8 hours of community service, collecting food and distributing it until there are 258 days that 58 hours that have been accumulated. I am not certain on the days of credit, but I am hearing you and Ms. Hanu in the fact that you may not have been given credit for the time that you were arrested over in Minnesota waiting extradition. I don't know if you were arrested for any other criminal purpose over there. It was simply this warrant.
Yes, Your Honor.
Yes.
So then those days should be added, but I will give Ms. Hanu 7 days to be able to get the confirmed date, but I will do 125 days credit, knowing that it most likely is going to change to the 131 or whatever that's going to be, but she can get that clarified and taken care of as quickly as probably a couple days, and then the judgment of conviction can be amended and modified.
Thank you for the latitude.
$3,175 in fines and fees. You have $2,450 previously posted, so you still will owe an amount $725. If the court, I'm debating whether or not to permit the ability to serve on electronic monitor for a few reasons. One, because of the, not allegations, they are the dismissed and read in counts of the drinking while on the IDIP program and drinking to an excess. I believe in one of them, it was a 0.2. I can't recall what the other one was, the BAC level. So that is making me hesitant upon granting that. Plus, it would be an additional, even if the court goes at the 131 days, an additional 34 days that would need to be prepaid ahead of time.
May I add something, Your Honor?
You may.
Initially in August, I was not engaged in IDIP at that point.
So in the first allegation of the drinking while on bond, you were still on my bond.
I was, there's no doubt about it, but just for clarification, I had not had conversations with Tessa Anderson in regards to the details of the IDIP. For whatever it's worth, it's just a clarity.
And I understand that. And then it leads me to believe, like, what do you, either way, you're on the court's absolute sobriety, no alcohol, no drink bond condition, and that was violated. So either way, there's 2 bail jump violations. The second one, you were already in the program, you needed to do the community service, and that was the only thing that was left. Either way, it doesn't look good in your favor, Mr. Mersha. What I am willing to do is, well, plus I have to add a $10 blood draw fee. What I'm willing to do is, if you pay off your fines and fees completely, And then you prepay for the 34 additional days on monitor, or whatever days it'll take you to come up with the rest of the money that's owed for your fines and fees, as well as for the monitor. Then the court will approve your release on monitor, but while on monitor, you must be working or completing that community service. And I must get continued validation and proof that you are doing actually both, because you only have 6 months to complete 258 hours. That's a lot of hours. If you equate it to 8-hour days, that's 32 or 33 days that would be straight 8-hour shifts that you have to work. So you're going to have a lot that you have to do, be in compliance. And you're going to need to return that monitor promptly after your days are over, because otherwise the court will issue a warrant for that return. You will be brought back and you could be sent to prison for failing to return that monitor, because it is a $3,000 or more device. This is going to be a withheld sentence, because I don't know what's going to happen from now until 2 years on probation. So it all depends on what you do. And this is that carrot that you have to show yourself, to show the world, to show the court that you're going to put yourself, your family first, and your sobriety first. And you're not going to violate the terms of probation. If you don't seek to prepay the monitor and to pay off your fines and fees, the remaining amount that's due, the court is going to order that it must be paid at $125 per month as a payment plan. Failing to pay your fines and fees means that the court will not only enter a civil judgment against you, because you're always going to owe it, but the court will also issue a warrant, and you could sit up to 6 months in jail. And you are on felony probation. That means it is extraditable. Any warrant the court issues is extraditable, and you will be extradited back to Wisconsin. 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. Getting there. No use or possession of a firearm for life. No voting in any election until your civil rights are restored. Also, Mr. Mersha, are you still at apartment 1308?
Yes,
And your telephone number ends in 0565.
that's correct.
Okay. Another term of probation is to follow any programming that your agent recommends or tells you must complete, including any drug and alcohol treatment court available in Minnesota, or if you are back in Burnett County, for the Burnett County Drug and Alcohol Treatment Court. Again, get the credit. You are to report to probation immediately. The court is ordering your DNA. You may be able to request it be expunged through a written letter to the Department of Justice, not to the court, to the Department of Justice. Mr. Vila, what is the court missing?
I think that covers it all, Your Honor.
Ms. Hanu.
Nothing, Your Honor.
If you are going to do the monitor, that is house arrest. So that means you can only be released for Huber. You can only be released to do community service or to the doctor. If there's anything outside of that, you must request permission from the court, and I will let you know. Even if there is a funeral, you may not be able to go unless it is a very close family member. You may not go to any parties. You may not go to any graduations. You may not go to anything unless it is approved by the court. This will test your alcohol and other substances in your system. It is a monitor that cannot be removed, so it will test 24/7. If it does indicate that there has been any indication of any violation, you will be told to immediately report to the jail. No good time, no Huber, because you will be immediately revoked. The court does not take excuses such as rubbing alcohol got spilled on it, or I was near gasoline, or I was using mouthwash and somehow that set the monitor off. You do not get a due process hearing with regards to this matter because it is a privilege, not a right to serve on electronic monitor. All right, if there's nothing else, then we are adjourned.
Oh, Joshua got a monitor strapped tight to his knee. It checks him 24/7 for the finest brewery. Don't blame the rubbing alcohol, don't blame the mouthwash too. 258 hours of community service for you. No graduations or parties, just sit right in your house. Unless you wanna go back to jail, stay quiet as a mouse.